ain't coming back. And I didn't. I kept my word. Do what, dear?
I said that you didn't. Matter of fact, I think for the rest of our court case, you had warrants for your arrest.
Uh-huh. And those did not get dismissed until I did the GSA bonds. And the DA and the judge actually changed how he talked about me, how he treated anything relating to me. He's even said he had it out to get me until I did that.
How do you submit them?
What did I submit?
I don't submit anything, but how do you file it?
Do what, dear? You started to say something, honey.
No, you're good. Answer his question. He wanted to know how you submit.
You got to fill out you got to fill out all the forms the right way. You got to get the initial presentment. The initial presentment was the petition. That's the negotiable instrument. You also got to attach a true copy of your birth certificate to that presentment. And you create a packet. And you send that entire packet, the original copies, privately registered mail, restricted delivery to the judge. Then you send a copy to the county executive, to risk management, to the lieutenant general at the Army Corps of Engineers, and to GSA.
Let's get a pen real quick so I can jot that down. Let's see. What else was I going to say? Isn't it against one of their codes to make copies of just like not certified copies, just like paper copies off of our printer of said certificates? I think I've come across something like that. But you said Army Corps of Engineers, huh?
The lieutenant general is the person that runs the Army Corps of Engineers. They got a gold fringe flag, right?
Yeah, true.
Okay.
Say something he did not as well.
No, under Army Regulation 84-10. Okay.
It's probably the third thing that I said.
Initially. Under Army Regulation 84-10, it can only fly in military controlled areas. Well, guess what they did? They contracted with the military through the cage code.
That's a new one, cage code. Yeah, but he just laughed off the code for the 84-10 or 2-6 gold fringe. Hell, he even denied admiralty jurisdiction whenever admiralty is actually in the Constitution. He claimed that it was an Article 3 court of record when it's clearly not. It's an Article 1, Section 8 under supervision of Congress. It's not that's just one of the many lies. Like,
are you talking about David Strange? Yeah.
No, the judge. The judge denied admiralty jurisdiction, and he denied anything about the gold fringe flag. It's like, it's freaking nonsense. So just...
He denied it because why? Everything you were saying was hearsay. You have not put one stitch of credible evidence into the court.
That's what it's so hard to accept. Like, it's just hearsay evidence, but it's in their code. I mean, come on. Like how
Did I not just explain to you the purpose of authentication? The authentication, it meets the rules of evidence. Until that statute code or whatever, you have to argue the fact of whether or not it is self-authenticating. You have to know that. If it is not self-authenticating, then you need to authenticate it. Once you authenticate it, then the judge has to take judicial notice of it, because now it meets the rules of evidence.
if we have to abide by those rules, shouldn't the presiding administrator have to follow the same exact rules and not just say the codes, but actually produce a certification of constitutionality of the said codes that they themselves rely on, because they don't. They just recite them just the same.
Do you know why the courts interpret the law?
To their prejudicial preferences, yes.
No.
With judicial discretion.
One, the reason why they interpret the law is, one, nobody brings the law. The court.
Yeah, now that's it. No factor truth shall be tried.
What?
Well, what are statutes and codes?
Not law.
That's right.
What?
They're only prima facie evidence of a law.
Hey, can
What are
I
you called?
intervene here and say something?
Yeah, Jesse, I'm gonna look something up right quick. You go ahead and take over.
Yes.
Everything is based upon hearsay, man. You know, idealistically
Is that
speaking, they
right?
should be doing all the things that you're saying, but that's not how it works. And you're going into someone else's house, right? And when you
So
go
much
into
wrong
someone
with it,
else's
'cause it's right
house,
up here.
they make the rules. So,
Yes.
yeah, you need to be taking that into account at all times. Quit thinking that they're going to do something that they're not acting in honor. It's incumbent upon you to act in honor and for you to bring your rights with you, right? So if there's nothing on the record, then what are we talking about here, right? Everything is based upon hearsay. So it's kind of like when you create your own trust and you put your own bylaws in the trust. Well, you don't allow anything outside of that to dictate the terms and the definitions of those words. So you create them yourself to define what exactly or precisely what it is that you're talking about. And then you take that with you, right? You're not just going in there on their terms and allowing them to dictate what this definition means or what this law is, because if you do, they're going to interpret it. It's open for subject interpretation, and they're going to use their interpretation that's most favorable and enlightened to them, right? So, like Pastor was saying, you need to bring your law in there with you, and you need to substantiate it, get it on the record, so that when you go up there, you can say, Your Honor, can you please take judicial notice of said such and such, right? And then you put them on the record, and you don't give them no other choice.
I can.
You're just going up there and arguing, and nobody gives a damn about what you think something should be. I mean, I know that's kind of harsh, but that's the reality of the situation. They don't care what you think. Anything that comes out your mouth that you can't substantiate is hearsay. And
Nothing. I'm doing a live. Jay in there.
Okay, now, I just shared a link in the group. Okay, this is called the bill drafting guides. Oh, if you look at the link, most of your states are published. You are in Texas.
I can.
You can download it right there. Okay? The reason why they interpret the law is nobody is holding them to what the drafting manual says. The attorneys don't read the drafting manual. The legislature don't read the drafting manual. That's the reason why when a new bill is put into the House, what does it have to do? It has to go to a judicial committee. The judicial committee then goes to the bill drafting guide and makes corrections before they vote on it. You want to get to where you write the law, you need to study your state drafting manual. It will tell you what words mean, how they are to be used, and how to use them correctly. That way you they can't interpret nothing after that.
I've been picking apart their paperwork, as far as, with David Windmiller's parse syntax. And
A load of crap.
like,
Gosh, get away from that. The legislature has the authority, according to the Constitution, at the state and the federal level, to write the law. They also have the power to define what words mean. The problem is you are listening to other people and assuming they know what the hell they're talking about and using their process, and you're getting it rammed in your ass. I just gave you the source on how to do the law, and you went to David Wynn Miller. And you're getting beat every which way you turn. Use their stuff against them.
I'm here to learn.
I know you are. David Wynn Miller and Robert J. Gould are so full of crap. They actually did a good thing when it comes to grammar, but they went overboard when they started getting into all the dash crap. The Bible lays out the principles. When Jesus put the child on his lap and said that you are to come to God as a child would. If you've got a child, if you say to your child and say, I'm going to the store, do you want anything? Well, yeah, can you get me a candy bar, Dad? Well, yeah, sure, I'll be back in a moment. Does that child start explaining away everything you say? Dad meant this because of this word means this and this word means that. No. But what do? We make things difficult.
They weren't quite at that stage yet, but they were at the stage of pitching a fit whenever they wanted something that they couldn't get. But because my oldest is 5 and I've got 3 of them, so. But
I learned this principle because of the void for vagueness doctrine. Every law has to be written in such a way that the common man and woman can understand it. If it is not, it is void for vagueness and unconstitutional and unenforceable. That's why I'm telling you, you got to go to their source information to see what they mean.
What about the 72-hour right of rescission? Because that's exactly what I did to all the documents that they did, especially on this past appearance, or quotation marks. But I wrote void. Your offer to contract is not accepted on every first page of the document.
It wasn't the court's offer to contract. It was your significant other that created the contract. You're going after the court. The court is only trying to settle a controversy. Who is the controversy between?
The arbiter.
That is, yeah. You and her have the controversy. The court's the innocent party. You are throwing things at the court like they're the bad guys.
Well, I have a question. Did you,
What?
Not you, for Jeff here, since you put void and no contract on these presentments, how did you, when you endorsed the instrument, how did you endorse it?
Jeff, power of attorney. This contract is void for fraud upon the court, according to Title 18, Section 1342, color of law. And because it is color of law.
Listen to what I'm saying here. I'm the police officer. I just pulled you over, and I'm writing you up a citation, and I present it to you. How do you endorse the instrument? What did you do with that instrument?
No, I would say your offer to contract is not accepted, written in red ink,
Hang on.
diagonally.
Wrong, Jeff, wrong. You gotta agree with thy adversary as quickly as possible, because you know what? If you don't sign that ticket, or you don't, you're sitting there and you're going to try to create some controversy on the side of the road, the police officer is liable to pull your ass out and put a knot on your head to take you to jail. What you do is agree with thy adversary, and you endorse that instrument with a byline, and you make a reservation of rights on it. Then you give him his copy, and you take yours back, and then you void it, and you send it to the proper channels within 72 hours. You don't create a controversy on the side of the road. You want to agree with his ass and be on your way as soon as possible. So you're creating a remedy, or you're putting an estoppel in their system before you ever get to the court, so that when you bring up those titles, you can say, hey, this is not a negotiable instrument. It was traded in fraud, or whatever the terms may be. And then you can bring up those things and say, under these titles, these things, or this United States Code, or whatever it is that you're going to use to back up what you're saying. You see what I'm saying? You're not trying to argue with these people. You're just going in there and you're saying that this is not a valid contract. But you have to establish it's not a valid contract before you ever get there.
I get what you're saying. I should have just signed it and used UCC 1-308, reserve all rights, and not create a controversy, which is what I did in the court case initially too. I said, I'm not the name. Here's the certificate. That's the entity that you are inquiring about, and use the securities on that bond to settle all matters. And I was
did you file it on the record? See, I mean, there's two parts to getting something on the record. There's you just going and filing it, and then there's you actually knowing that you're on the record, and then you saying, hey, judicial notice of such and such, and then you take it and you read it yourself, or you make to present me. Right? It's not just you going and filing it on the record in your case. You've got to get it on the record, right? You only have the rights that you bring with you. So you got to, every step you make, you've got to be creating a record so that you have something to go back to reference that they can't deny. The record is everything, man. What's on the record is the only thing that matters. It does not matter what comes out of your mouth. Okay, it's irrelevant what's coming out of your mouth if it does not match up to the record. They're just going to ignore you or think that you're just babbling.
The record, if you think of the record as in the mouth of 2 or 3 witnesses, first it comes out your mouth. Second, it's on paper. The paper goes into the file. Does what came out of your mouth in the transcripts match what's in the file?
I thought even if it's not filed before the case, even other opposing lawyers introduce new presentments during.
But you're not a lawyer. You're not a lawyer. They're not going to give you the same respect that they give those guys until you make them respect you.
It should be whatever I say goes. I'm like there. So.
No, it is not whatever you say goes. That's not how it works.
I know it's not that way. I'm just saying, to me, it should be.
It's never been that way. Even attorneys, you need to go read the court case, Trenzi versus Pagliaro. Even an attorney cannot. The only reason their stuff is accepted on the record is because nobody objects to the fact that everything they say is hearsay. Because why? Trenzi versus Pagliaro. They have no first-hand knowledge.
I use that.
If you overdraw your account, Wells Fargo gives you an extra day grace period to avoid the overdraft fee. What if...
I use use that.
No, all they at the end of the day really have is your silence, is acquiescence, that you're just going along with this process.
I've got the record to prove otherwise. I've got the oral, the oral record, because that's the only one that they used, and it's not even a court of record. It's not an Article 3 court. Who knows what they've hidden?
Well, they obfuscate everything. That's what they do. They'll even change the record if they have to.
Yeah, because it's a private Barfield matter.
Yep, absolutely. Well, the best thing to do is just to try to stay out of their venues at all costs. If you can handle, figure out how to do the administrative process where you don't have to go in there, I would recommend that. I know
I'm not sure how much longer I can suffer this injustice, though.
I did it
Without
for 7
losing.
years.
All I know is if you go into this venue, you're always likely to get thrown in jail, so you just got to be prepared for that.
I've been there, done that. I got the T-shirt, but it's just I'm studying my ass off to show myself approved, and I'm determined to get there.
Well, I know you're determined.
And then get all your debts in the public settled, and you just walk away from that shit. Be done with it. You're trying to fight them, right? Stop fighting them and become the principal so they'll start protecting you instead of you going to war with them. Because you're not going to win. You're not going to win a commercial war against them. They've got all the manpower and everybody's on their side.
I try to agree, with them rapidly. Agree with thy adversary rapidly, and give Caesar what is Caesar's.
But in this case, your adversary is her. She is the reason why this has started. And the state wants to be her husband, so they take the interest in her case to come to her aid.
But I know, I'm all ears. I'm not trying to argue at all. It's just, I was not in the capacity of an incompetent minor because I was not having somebody speak for me.
That doesn't prove you're not a minor. If you would have actually not argued the case, which is what you have done, everything you told me you've done has argued the public debt. You've argued the case.
Even trying to turn over the bonds. I mean,
where's your evidence there's bonds?
I actually found my CUSIP number from my birth certificate. I wrote it down. I found it.
How did
on
you
Fidelity?
find it?
On Fidelity.
I bet you didn't.
Hey Jeff.
Some pictures of all the numbers.
Jeff, do you understand what Pastor is saying when he's saying that you were arguing the national debt? Do you grasp what he's saying by that? So back in 1933, when they created the New Deal, they put a provision in there that said that the national debt is not to be questioned. Right? So anytime you go in somewhere and you argue, you're creating a controversy, which is basically saying that you're arguing over this debt that's owed. Right? And it puts you in dishonor. So you don't ever want to go in there and argue with them. You don't want to create a controversy. You're in here as a third-party intervener on behalf, of the Sister KV Trust, or however you want to, put it out there, and that you're going to surrender over to the court and give them whatever they want, right? Because you're going to agree with our adversary. Never go in there and create a controversy. Never go in there and say you're guilty or innocent, because now you're arguing, you're creating a controversy. I'm innocent until proven guilty only. It's all a trap to get you in controversy so that they can come in and settle the dispute. That's what the Civil War is all about.
I know exactly what. I don't know how to say that I tried that. I turned over the certificate. I'm like, I don't want to create it. I specifically said that while I was doing it. I don't wish to create any controversy. I wish to settle this matter, this debt right now.
You did it at arraignment, did you not? Did you create a controversy at arraignment? What did you plead? Did you plead guilty, not guilty? Like, I mean, what did you do at arraignment?
This is a custody battle, so it was a plea.
So it's private, then, so that's different. Okay, did you have a marriage license?
No, we were not married. We were together for 6 years, but we were not married. No, I would never marry you.
No. This is where you're wrong. I tried to explain this
common law.
last night.
I know they only use common law whenever it benefits them.
I am not saying common law. That is the statutory provision trying to mirror what God set up. Okay? Did Isaac, when he married Rebekah, did he ever have a ceremony and a marriage license? No. It said the moment he saw her, he loved her from afar. And the moment he took her in the tent and consummated the relationship, according to the testimony in the Bible, that was his wife. You never once brought scripture into this to show that your wife was in dishonor according to her first contract, which was the marriage according to scripture. Trey Ben, you can't get in touch with her. I don't know what happened to her. But she did this for a guy in New Hampshire. His wife came after him. And guess what? When she argued from the scriptural contracts, she lost the case. Because that's what she used to show the wife was in dishonor. Because the state will never trespass on what is God's. The marriage license is the state's. The contract of matrimony is private.
Whenever I filed my response to their final orders, I did use scripture. I think I did as well in some initial documents as well. But the final one, whenever I voided all the contracts, whether it works or not, I did bring up the initial misjoinder of parties because I have every right to self-determination, and I am not a person. And I've got probably 50 verses from the Bible that says that I